Hello everyone, welcome to Vidhigya Explained series. The topic for today's discussion is contempt of court. So in this topic, we'll discuss about what is contempt of court, what are the constitutional or legal provisions related to contempt of court and the necessity of contempt to court. So we have in past few years, we have seen that many contempt of court cases have been filed in the Supreme Court and High Court. For example, the most important case that you might remember about the case of Prashant Bhushan. So he has written some article, he has made some comment in the interview. So on that basis, the contempt of court was like he was prosecuted for contempt of court. So then we will discuss about everything about contempt of court. So first thing, the contempt of court law is one of the most controversial elements in the Indian legal context. So it is most controversial. Why is it most controversial? Controversial provision because it is a very subjective thing. There is no written definition or no written definition which clearly say that such and such act is will fall under contempt of court. That's why it, because of its subjective interpretation, because of its different interpretation, like it can take any statement on any sentence can take form of contempt of court. So that is why it is the most controversial, because it is not codified as such that what constitutes contempt of court in particular. So while the basic idea of contempt law is to punish those who do not respect the orders of the court, so the basic idea is to punish those who do not follow the order of court, who do not follow order of court. Contempt is also used to punish speech that lowers the dignity of the court and interferes with the administration of justice. So when any statement is made by anyone which lowers the dignity of court which interferes with the administration of justice, so in that sense also it can be considered to be contempt of court. So contempt of court, it is of two kinds. First, civil, second, criminal. So what is civil? So willful disobedience of a court order or judgment, or willful breach of an undertaking given to court. For example, a judgment is given, an order is passed by court, and the person is not following the judgment, or not acting as per the order, or disobeying the judgment or order. And when the person has given some undertaking and he is not following that undertaking, in that case, it is civil contempt. So it is simple willful disobedience of court order or judgment. Now criminal. What is criminal court of contempt? So it is a written or spoken. First thing, it is a written or spoken or any act. That is written or spoken words or any act that scandalizes the court or lowers its authorities or prejudices or interferes with the due course of judicial proceeding or interferes or obstructs the administration of justice. So this is criminal contempt. For example, if a person is saying that the Supreme Court does not hold any value and the judges are corrupt of Supreme Court, so what will this give him? This will give an impression to the public that the Supreme Court does actually work in that way, and therefore it will affect in the administration of justice, and it will also lower the reputation of the court. That falls under the criminal contempt of court. So it said scandalizes the court or lower its authority or prejudices or interferes with the due course of judicial proceeding. So that is contempt of court. So we have learned about civil contempt of court and criminal contempt of court. Now, one thing I would like to tell you, the contempt of court, there are two ways. One is suo moto. Suo moto means by itself. By itself. For example, if a statement is made or any act is done, and the Supreme Court itself takes action that, okay, we will take action under Contempt of Court Act. So this is suo moto. And when another is through another process, for example, like if a person has said something about court and then B approaches the court that the statement made by A has actually falls under contempt of court proceeding, contempt of court criteria. So there are two ways. So in this case, what you have to, if a person is going for a contempt of court, then he has to go to attorney general for getting his permission. So first, what will happen? Attorney general will see the application and will judge whether it is actually contempt of court or not. If the Attorney General gives permission, then the court will take up the matter. If Attorney General does not give the permission, then the court does not take up the matter. So the purpose of this is that they're not frivolous litigation. So like anyone coming, okay, now we are filing contempt of court case against this person. So in order to reduce this is inserted that so that it is filtered through Attorney General, and only serious cases can be taken by the court. So there are two ways we have discussed, by suo motu and through Attorney General. Now relevant provisions. So the relevant provisions related to contempt of court, Article 129 and 215 of the Constitution. So there are two articles, Article 215, Article 129. Under Article 129, Supreme Court is empowered to punish for contempt of court. Under 215 article, High Court is empowered to punish for contempt of court, both civil and criminal. Here also both civil and criminal. So now there is also Contempt of Court Act, Contempt of Court Act of 1971. It gives the procedure. So it defines the power of High Court to punish contempt of its subordinate court. Under Section 10, the High Court can also punish for contempt of court for subordinate court. For example, district courts and session courts. So High Court has the power under Section 10 of Contempt of Court Act to punish for contempt of court when it comes to contempt of its subordinate court. So this is there. However, the Constitution also includes contempt of court as a reasonable restriction. So there is also a reasonable restriction to the freedom of speech and expression under article, along with elements like public order and defamation. So this we will discuss in this slide. And then why courts need contempt. So to ensure their orders are implemented, as we have said, because in civil contempt, this is the willful disobedience. First thing is. Second, to sustain the independence nature of judiciary itself, so that there are no false allegations against the court, and otherwise it will lower the authority, or the trust of the people on the court will reduce. So because of these reasons, the court needs contempt of provision. So issues. So under Article 9, everyone is given freedom of speech and expression, but there are certain reasonable restrictions. And this reasonable restriction, so contempt of court comes under the reasonable restriction. So the law is very, so Article 9(1)(a) of the Constitution gives right to freedom of speech and expression to all citizens, while contempt provision curbs the freedom to speak against the court's functioning. However, this is a reasonable restriction. At the same point of time, Article 19(1) gives freedom of speech and expression. So this contempt provisions goes against the freedom of speech and expression. So this is the issue with contempt provision, that on one hand there is freedom of speech and expression, and on the other hand, because of reasonable restriction on the basis of contempt of court, you restrict the freedom of speech and expression. So this is the issue. And I've told you, because law is very subjective, which might be used by judiciary arbitrarily to suppress their criticism by public. So because it is subjective, so there is a scope of arbitrary use of this. So now 5 important questions related to this topic. Question number 1, contempt of court is of how many types? So your options are 2, 1, 3, none of the above. So the correct option is 2 types. We have discussed criminal contempt of court and civil. And civil is willful disobedience of judgment, order, or undertaking. Criminal contempt of court, which scandalizes or lowers the authority of the court, or prejudices or interferes with the administration of justice. So this is criminal contempt of court. This is civil contempt of court. So question number 2, under which article of the Constitution of India High Court is empowered to punish for contempt? So here High Court. So your options are 129 article, Article 215, Article 19, none of the above. The correct option is Article 215. Question number 3, same question, but under which article of Constitution of India Supreme Court is empowered? Now Supreme Court is empowered under which article? Your options are Article 129, Article 215, Article 19, none of the above. The correct option is Article 129. Question number 4, contempt of court is a reasonable restriction on freedom of speech and expression under which article? Your options are 129, 215, Article 19, and none of the above. The correct option is Article 19. It is a restriction on freedom of speech and expression. Question number 5, last question, Contempt of Courts Act came into effect in which year? Your options are 1971, 1972, 1973, none of the above. The correct option is 1971. So we have discussed everything related to this topic. So just try to remember all these articles and the kinds of provisions are there, and like types of contempt of court. So that's all for today's session. Stay logical with Vidhigya, your best pal in CLAT Preps.